Hello everyone and welcome to today's class. So our today's topic is CCS CCA Rules 1965. This comes under paper 2 of AAO Exam syllabus. In this we are having chapter number 1, where we will read about the appointing authority, suspension, penalties and disciplinary authorities, procedure for imposing penalties, appeals, revision and review. We also have chapter number 2, suspension, chapter number 3, suspension general orders, chapter number 4, suspensions entitlement, chapter number 7, unauthorized absence, and chapter number 15, orders regarding grant of TA to various persons during disciplinary proceedings. So let's start with our chapter 1. Before chapter 1, we have some definitions. So rule 2 is generally about the definitions. So rule 2A is appointing authority in relation to a government servant. So who is our appointing authority? The authority empowered to make appointments to the service of which the government servant is for the time being a member, or to the grade of service in which the government servant is for the time being included, or the authority empowered to make appointments to the post which the government servant for the lifetime be hold. Government servant for the time being holds, or the authority which appoint the government servant to such service, grade or post as the case may be. Where the government servant have been a permanent member of any other service, or having substantively held any other permanent post, had been in continuous employment of government, the authority which appointed him to the service or to any grade in that service or to that post. Whichever authority is the highest authority is our appointing authority. In simple language, appointing authority is the one who under which the cadre to which the government servant belongs is being appointed. Generally, in case of PASA, the appointing authority is either SSPOs or SPOs. In case of postman and lower cadre like MTS, appointing authority may be either the divisional head or the subdivisional head. Okay. Now, in definitions, disciplinary authority. Who can be the disciplinary authority? Disciplinary authority means the authority competent under these rules to impose on a government servant any of the penalties specified in Rule 11. So, authorities superior to the cadre who can impose any penalty specified under Rule 11 to a government servant is our disciplinary authority. Generally, appointing authority is himself the disciplinary authority. That is, any charge sheet or any final order needs to be signed by the disciplinary authority, which is in general most of the cases the appointing authority himself. Head of the department. For the purpose of exercising the powers as appointing disciplinary appellate or reviewing authority means the authority declared to be the head of the department under fundamental and supplementary rules. Here, head of the department means authority which is superior to the disciplinary or appointing authority, or maybe same. So if he is superior to the appointing or disciplinary authority, then he will also be available for appeal purpose. Like in case Rule 14 charge sheet is given to a PA cadre, then his appointing authority is, let's say, SSPOs. So for appeal purpose, he will appeal to whom? He will appeal to the superior of the SSPOs. So in our case, the superior is DPS headquarters. Similarly for inspector cadre, the superior appointing authority is DPS headquarter, and the superior of DPS headquarter is Chief PMG or Chief Postmaster General or Postmaster General. So the appealing authority will be the CPMG or PMG in case of IPOs. Now, head of the office. For the purpose of exercising the power as appointing disciplinary, appellate, or reviewing authority means the authority declared to be the head of the office under Rule 14 of Delegation of Financial Powers. Here, head of the office will have the powers as appointing authority, disciplinary authority, sometimes maybe appellate authority or reviewing authority as well. Next, Rule 6 is, one second, let's go to our slide. Yes. Rule 6, classification of posts. So, under central services, posts are classified as Group A, Group B, Group C, Group D. But after third CPC, Group C has been replaced and it is now only up to Group A, Group B and Group C. Group D has been merged with Group C. That is from 2006. Group D post is designated as multitasking staff and has been upgraded as Group C with effect from 1/1/2006. So generally people with pay level 1 to 5 comes under Group C, from pay level 6 to 9 comes under Group B, and those above level 9 comes under Group A, that is from pay level 10 to 18 the government officials come under Group A. Next is our rule number 8, appointments to Group A services and posts. We all know that all appointments to Group A cadre is made by the president. Okay. Provided that the president may, by a general or special order and subject to such condition as he may specify in such order, delegate to any other authority the power to make such appointments. In this case, any other authority which has been delegated the power is also eligible for appointment of Group A. Rule number 9 is appointment to other services and posts. All appointment to central civil services, Group B, Group C and Group D shall be made by the authorities specified in this behalf in the schedule. Rule number 10 is very important. Rule number 10 is suspension. Appointing authority or any authority which it is subordinate, or the disciplinary authority or any other authority empowered in that behalf by the president by general or special order may place a government servant under suspension. Where a disciplinary proceeding against him is contemplated or is pending, or where, in the opinion of the authority aforesaid, he has engaged himself in activities prejudicial to the interest of security of state, or where a case against him in respect of any criminal offense is under investigation, inquiry, or trial. So, what are the 3 cases where a government servant will be placed under suspension? One is when a disciplinary action has been initiated against him and is pending. So, only for inquiry purpose, that is his presence, if it is felt that his presence may temper any witness or may cause any problem to reach the conclusion, then in such cases suspension order is given. Suspension order is given. So the reasons are A is disciplinary proceeding, B is when he has engaged himself in activities prejudicial to the interest of the security of state, and where a case against him in respect of any criminal offense is under investigation, inquiry, or trial. So in 3 cases, mandatorily, if it is felt by the disciplinary authority, the official will be placed under suspension. For option A and B, he will be mandatorily sent on suspension. But in case of Rule 1A, 10(1)(a), as per the decision of the disciplinary authority, the official will be placed under suspension. A government servant shall be deemed to have been placed under suspension by an order of appointing authority, with effect from the date of his detention if he is detained in the custody, whether on a criminal charge or otherwise, for a period exceeding 48 hours. So if a person has been detained for more than 48 hours, then he is deemed to be placed under suspension. Also, with the effect from the date of his conviction, if in the event of conviction of an offense he is sentenced to a term of imprisonment exceeding 48 hours and is not forthwith dismissed or removed or compulsorily retired consequent to such conviction. So one is from the date of his detention and other is from the date of his conviction. In case of detention, it is 48 hours. In case of conviction also, if the period is more than 48 hours, the government servant is deemed to have been placed under suspension. Where a penalty of dismissal, removal, or compulsory retirement from service imposed upon a government servant under suspension is set aside in appeal or review under this case under these rules, and the case is remitted for further inquiry or action, or with any other direction, the order of his suspension shall be deemed to have continued in force on and from the date of the original order of dismissal, removal, or compulsory retirement, else shall remain in force until further orders. So, if the official, as a penalty has been awarded with dismissal, removal, or compulsory retirement, and then he has appealed against his final order, and his appeal was reviewed, and his case is sent for inquiry, further inquiry, then in such cases also he will be deemed to be on suspension until the inquiry is complete from the date of his order of dismissal or removal or compulsory retirement. Where a penalty of dismissal, removal, or compulsory retirement from service imposed upon a government servant is set aside or declared or rendered void. So, in this case, the government appeal was for fair enough reason, and his disciplinary case or the final order of dismissal, removal is set aside or declared or rendered void by any court or the disciplinary authority. In such circumstances, disciplinary authority will decide whether to hold further inquiry or just to place him as regular duty, provided that no further inquiry shall be ordered unless it is intended to meet a situation where the court has passed an order purely on technical grounds without going into the merits of the case. Or else, if inquiry is going on against the order of appellate authority, then the government servant will deem to be still under suspension by the appointing authority. Subject to provisions contained in Sub-Rule 7, an order of suspension made or deemed to have been made under this rule shall continue to remain in force until it is modified or revoked by the authority competent to do so. Until and unless the suspension order is revoked, the government official will assume to be under suspension. Where a government servant is suspended or is deemed to have been suspended, and any other disciplinary proceeding is commenced against him, that is, two disciplinary proceedings are going on against one single government official, then the authority competent to place him under suspension may, for reasons to be recorded by him in writing, direct that the government servant shall continue to be under suspension until the termination of any of the proceedings. So the decision will be purely of the disciplinary authority. An order of suspension made or deemed to have been made under this rule may at any time be modified or revoked by the authority which made or is deemed to have made the order, or by an authority to which the authority is subordinate. So either the competent appointing authority or the disciplinary authority can modify or revoke the suspension anytime, whenever deemed fit by as per their opinion. An order of suspension made or deemed to have been made under this rule shall be reviewed by the authority competent to modify or revoke the suspension before expiry of 90 days. So, before expiry of 90 days, order will have to be reviewed on the recommendation of review committee constituted for this purpose, and pass orders either to extend or to revoke the suspension. Subsequent reviews shall be made before expiry of the extended period of suspension. Extension of suspension shall not be for a period exceeding 180 days at a time. So, to the maximum, already 90 days have elapsed. So, on review, if they feel to extend the suspension to the maximum of more of 6 months, they can extend up to 6 months. That is 6 plus 6 up to 12 months, or 180 days only, they can extend the suspension. So maximum limit will be first 3 months and then again 3 months, so total 6 months. After 6 months, it will again have to be reviewed. Okay. An order of suspension made or deemed to have been made under sub-rule 1 or 2 of this rule shall not be valid after a period of 90 days unless it is extended and reviewed. So if the review is not done, then it is opined that his suspension has not further been extended and he can resume his normal duty, provided that no such review or suspension shall be necessary in case of deemed suspension. So in case of detention or conviction as per sub-rule 2, such review is not necessary. Now come the rule number 11, Rule number 11 is most important and is a definite question for syllabus, our AAO exams. Simply, it can be asked that what are the major penalties and minor penalties. So there are 3 major penalties, 3 minor penalties, and 4 major penalties under Rule 11 of CCS CCA Rules. So let's first study the minor penalties. So under Rule 11, let us study the penalties. Altogether, we have 9 penalties. 4 are minor penalties and 5 are major penalties. So let's see what are our minor penalties. So following are the minor penalties. One is censure. Censure is generally just a warning that you have been given chance for this time, and please do not repeat the same mistake for the next time. So censure is the most basic and least harming minor penalty. Second is withholding of his promotion. That is not allowing the government servant for his promotion for some special period of time. Third is recovery from his pay of the whole or part of any pecuniary loss caused by him or the government by negligence or breach of orders. So the loss made by him being the main offender or the subsidiary offender. So in such cases, the amount of loss is being recovered from him. So it is our third penalty. In 3A, we have reduction to a lower stage in time scale of pay by one stage for a period not exceeding 3 years without cumulative effect, not adversely affecting his pension. So here the government official is reduced to reduced by one stage in his pay level for not exceeding 3 years and without having any cumulative effect. That is, after the completion of the given period, which is to the maximum can be 3 years, after that he will again be placed under the time, pay scale where he would have been if he was not given this punishment. So here no cumulative effect is given to the reduction of pay, that is the order given by the authority, and which shall also not adversely affect his pension. Then our fourth minor penalty is withholding of increments of pay for some specific period. So these are our 4 minor penalties. We need to memorize it because yes, it is a very important question and it can surely be there in our exam. So 1 is censure, 2 is withholding of promotion, 3 is recovery from pay of the part or the full amount of loss caused by the government servant to the government. 3A is reduction to lower stage in time scale of pay by one stage for a maximum period of 3 years without any cumulative effect and not adversely affecting his pension. Fourth penalty is withholding of increments of pay. Okay, so these are easy. We just need to memorize it. Then we have our major penalties. Total 5 major penalties we have. So first major penalty is reduction to a lower stage in time scale of pay for a specific period with further direction as to whether or not the government servant will earn the increments of pay during the period of such reduction and whether on an expiry of such period the reduction will or will not have the effect of postponing the future increments of his pay. Let us once again go through it. Reduction to a lower stage in time scale of pay for a specific period. So the specific period will have to be there given clearly in the order. Also mentioning whether this reduction will earn increments of pay during the period of such reduction and whether on expiry of such period the reduction will or will not have the effect of postponing the future increments of his pay. Major penalty number 2 is reduction to lower time scale of pay, grade, post or service for a period to be specified in the order of penalty, which shall be a bar to the promotion of government servant during such specified period to the time scale of pay, grade, post or service from which he was reduced, with reduction as to whether or not on promotion on the expiry of the specific period. So in this case, the reduction to lower time scale shall be a bar to the promotion of the government servant during such specific period to this time scale of pay, and with direction as to whether on promotion on expiry of the specific period, the period of reduction of time scale of pay, post or service shall operate to postpone future increments of his pay, and if so, then to what extent? The government servant shall regain his original seniority in the higher time scale of pay, grade, post or service. So here the promotion is barred, and also it shall be it's clearly written in the order that period, how to treat the period, whether the period of reduction of, shall postpone the future increments of his pay, and if so, to what extent, and when the government servant will regain his original seniority in the higher time scale of pay, grade, post, or service. So, third major penalty is compulsory retirement. Fourth major penalty is removal from service, which shall not be a disqualification for future employment under the government. So that means that when a government servant is removed, he can again get himself employed under either state or central government or any other PSUs. So it shall not be there shall not be any part of his joining any government service. But rule number 9 is dismissal. When an official is dismissed, so he will be disqualified for any future employment under the government. So these are our 5 major penalties. Let's quickly once again go through it. The first major penalty is reduction to lower stage in time scale of pay for a specific period, with further direction as to whether the government servant will earn increments of pay during the period of such reduction, and whether, on expiry of such period, the reduction will or will not have the effect of postponing the future increments of his pay. Second one major penalty is reduction to lower time scale of pay, grade, post, or service for a period to be specified in the order of penalty, which shall be a bar to the promotion of government servant during such specific period to time scale of pay, grade, post, or service from which he was reduced, with direction as to whether or not, on promotion, on the expiry of the said specific period, the period of reduction to time scale of pay, grade, post, or service shall operate to postpone the future increments of his pay, and if so, then up to what extent, and lastly, when government servant shall regain his original seniority in the higher time scale of pay, grade, post, or service. Third one is compulsory retirement. Fourth is removal from service, which shall not be a disqualification for future employment. And fifth is dismissal from service, which shall be a disqualification for future employment under the government. Hello everyone, and welcome to the second part of our session of CCS CCA Rules. In our previous session, we have completed up to major penalties, that is rule number 11. Up to rule number 11 we have completed. We have read about our 4 minor penalties and 5 major penalties. Now let's continue from rule number 12. Rule number 12 says that for every cadre there is a schedule regarding the appointing authority, disciplinary authority, and appellate authority. As for instance, please see the notification dated 9/4/2010. Disciplinary authority will take action as per the provision laid down in the prescribed schedule. Officers performing current duties of a post cannot exercise statutory power under these rules. Rule 13. Authority to institute proceedings. The President or any other authority empowered by him, by general or special order, may institute disciplinary proceeding against any government servant, direct a disciplinary authority to institute disciplinary proceedings against any government servant or whom that disciplinary authority is competent to impose under these rules any of the penalties specified in Rule 11. A disciplinary authority competent under these rules to improvise any of the penalties specified in Clause 1 to 4 of Rule 11 may institute disciplinary proceeding against the government servant for the imposition of any penalties specified in Clause 5 to 9 of Rule 11, notwithstanding that such disciplinary authority is not competent under these rules to impose any of the later penalties. So, minor penalties can be implemented by disciplinary authority, but the major penalties can be instituted or imposed only by the appointing authority, is also who can also be the disciplinary authority consecutively. So if he is also the appointing authority, he may execute or impose the major penalties. Otherwise, if the disciplinary authority is lower in cadre than the appointing authority, then he may impose only up to minor penalties. For the major penalties, he have to forward his charge sheet to the higher authority for final approval. So we have learned that disciplinary authority can impose penalties, only minor penalties, and for major penalties, if the disciplinary authority is the appointing authority himself, then only he can impose the major penalties. Otherwise, it has to be forwarded to the higher authority for final approval. Rule 14. Rule 14 is procedure for imposing major penalties. No order imposing any of the penalties specified in clause 5 to 9, that is, major penalties of Rule 11, shall be made except after inquiry, as far as may be in the manner provided in this rule and Rule 15, or in the manner provided by the Public Servant Inquiries Act. So, for implementation of major penalty, inquiry is must. Inquiry must be held before finalization of the case. Whenever the disciplinary authority is of the opinion that there are grounds for inquiring into the truth of any imputation of misconduct or misbehavior against a government servant, it may itself inquire into or appoint under these rules or under the provision of public servants' inquiries, as the case may be, an authority to inquire into the truth thereof. So the disciplinary authority can either himself or he can appoint someone to inquire into the matter, and he appoints another person, then he will be known as IU, inquiry officer, where it is proposed to hold an inquiry against the government servant under this rule, and the disciplinary authority shall draw up or clause to be drawn up the substance of imputation of misconduct or misbehavior into definite and distinct article of charges. That is, charge sheet need to be prepared. A statement of imputation of misconduct or misbehavior in support of each article of charge, which shall contain a statement of all relevant facts, including any admission or confession made by the government servant, a list of documents by which and a list of witnesses by whom the articles of charge are proposed to be sustained. So, the charge sheet shall contain the following things. One is a statement of relevant facts, including any confession made by the government servant, and list of documents and list of witnesses, which will help him to sustain the case. The disciplinary authority shall deliver or cause to be delivered to the government servant a copy of article of charges, that is the charge sheet. Okay, the statement of imputation of misconduct or misbehavior as a list of documents and witnesses by which each article of charges is proposed to be sustained, and shall require the government servant to submit within such time as may be specified a written statement of his defense, and to state whether he desires to be heard in person. So first a charge sheet is given, then his statement or confession is taken, then a list of documents by which and list of witnesses by which we are going to prove the charges should be made, and it should be delivered to the government servant so that he may know regarding all the charges against him. Also, he is given time to reply against the charges made against him. He shall reply with a written statement of his defense and to state whether he desired to be heard in person. On receipt of the written statement of defense, the disciplinary authority may itself inquire into such article of charges and as are not admitted, or if considered it necessary to do so, appoint an inquiry authority for the purpose, and where all the article of charges had been admitted by the government servant in his written statement of defense, the disciplinary authority shall record its findings on each charge after taking such evidences and as it may think fit, and shall act in the manner laid down in Rule 15. If no written statement of defense is submitted by the government servant, the disciplinary authority may itself inquire into the article of charges, or may, if it considered it necessary to do so, appoint under sub Rule 2 an inquiry authority for the purpose. Where the disciplinary authority itself inquires into and the article of charge of appoints are inquiring an or article of charge into any article of charge or appoints an inquiry authority for holding an inquiry into such charge, it may, by an order, appoint a government servant to a legal practitioner or a legal practitioner to be known as presiding officer to present on his behalf the case in support of the article of charges. When a disciplinary authority appoints an inquiry officer, then the official at charge, that is, our government servant, may also appoint another government servant or a legal practitioner, which will be known as presenting officer (PO), to present on his behalf and supporting the article of charges. Rule 15 is action on inquiry report. The disciplinary authority, if it is not itself the inquiring authority, may, for reason to be recorded in its writing, remit the case to the inquiry authority for further inquiry and report. An inquiring authority shall thereupon proceed to hold further inquiry according to the provisions of Rule 14 as far as may be. The disciplinary authority shall forward or cause to be forwarded a copy of the report of inquiry, if any, held by the disciplinary authority, or where the disciplinary authority is not the inquiring authority, a copy of the report of inquiring authority together with its own tentative reason for disagreement, if any, with the findings of inquiring authority on any article of charge to the government servant, who shall be required to submit, if he so desires, his written representation or submission to the disciplinary authority within 15 days, irrespective of whether the report is favorable or not to the government servant. So here we understand that the disciplinary authority, dependent upon the report of the inquiry authority and also including his own findings, will prepare a copy of inquiry report and then send the same to the charged government official. The government servant, on receipt of the same, he may submit one written representation if he disagrees with any of the charges or inquiry report. If he disagrees, he can submit his own representation within 15 days of receipt of such report. In every case where it is necessary to consult the commission, The disciplinary authority shall forward or cause to be forwarded to Commission for its advice a copy of the report of the inquiring authority together with its own tentative reason for disagreement, if any, with the findings of inquiry authority on any article of charge, and comments of disciplinary authority on the representation of the government servant on inquiry report and disagreement note, if any, and in all cases records of the inquiry proceedings. The disciplinary authority shall forward the copy of advice of the commission received to the government servant who shall be required to submit, if he so desires, his written representation or submission to the disciplinary authority within 15 days on the advice of commission. So in cases where it is required to consult the commission, the detailed report will be sent to the commission, and the report received from the commission or the advice received from the commission will be communicated to the government servant, and again the government servant, the charged official, if he so desires, may submit his written representation on the advice of the commission. The disciplinary authority shall consider the representation, if any, submitted by the government servant and records its finding before proceeding further. If the disciplinary authority, having regard to its findings on all or any of the articles of charge and on the basis of the evidence abducted, findings on all or any of the article of charge, is of the opinion that any of the penalties specified in 1 to 4, that is major penalty, or 5 to 9, minor and major penalty. 1 to 4 is minor and 5 to 9 is major, whichever is admissible, and will impose such penalty on government servant which he deems fit to be imposed, and make the final order of such penalty. It shall not be necessary to give the government servant any opportunity of making representation on the penalty proposed to be imposed. So, it depends upon the disciplinary authority. He is the final deciding authority. He will see the inquiry report and the representation made by the government official, defense representation made by the government official. He will again check upon the charges and, as deemed fit, will impose the either major or minor penalties to the government servant. Then is Rule 16. Rule 16 is procedure for imposing minor penalties. Subject to the provision of Rule 5 or Rule 15, no order imposing on a government servant any of the penalties specified in Clause 1 to 4 of Rule 11 shall be made except after informing the government servant in written of the proposal to take action against him and of the imputations of misconduct or misbehavior on which it is proposed to be taken, and giving him reasonable opportunity to make any representation as he wished to make against the proposal. Holding an inquiry in the manner as laid down in Rule 14 in every case is in the opinion of the disciplinary authority. Taking the representation, if any, submitted by the government servant and record of inquiry, if any, held under, may be taken into consideration. If required, only then consultation of commission will be taken, and where such consultation is taken, the disciplinary authority will forward a copy of the advice of commission to the government servant, who shall be required to submit, if he so desires, in his written representation or submission on the advice of the commission to disciplinary authority within 15 days. Rule 17 is communication of orders. Orders made by the disciplinary authority shall be communicated to the government servant, who shall also be supplied with a copy of its finding on each article of charge, or where the disciplinary authority is not the inquiring authority, a statement of findings of the disciplinary authority together with the brief reason of its disagreement, if any, with the findings of the inquiry authority, and where the disciplinary authority has not accepted the advice of the Commission, a brief statement of reasons for such non-acceptance shall be made. Where two or more government servants are concerned, in any case, the President or any other authority competent to impose the penalty of dismissal from service on all such government servants may make an order directing the disciplinary action against all of them may be taken in a common proceeding. When more than one individual is involved, then Rule 18 will come. Subject to the provision of Rule 12, any such order shall specify the authority which may function as disciplinary authority for the purpose of such common proceeding, the penalties specified under Rule 11 which such disciplinary authority shall be competent to impose, whether the procedure laid down in Rule 14 and Rule 15 or Rule 16 shall be followed in the proceeding. Rule number 19 is special procedure in certain cases. Notwithstanding anything contained in Rule 14 to Rule 18, where any penalty is imposed on a government servant on the ground of conduct which has led to his conviction on a criminal charge. So, whenever there is a criminal charge involved, Rule 19 will take place. Where the disciplinary authority is satisfied for the reason to be recorded by it in writing that it is not reasonably practicable to hold an inquiry in the manner provided in these rules, or where the President is satisfied that in the interest of security of state it is not expedient to hold any inquiry in the manner provided in these rules, the disciplinary authority may consider the circumstances of the case and make such order as it deems fit, provided that the government servant may be given an opportunity of making representation on the penalty proposed or to be imposed before any order is made in a case under clause 1. That is, before finalizing his disciplinary case or giving last order of penalty, he must be heard in person and he should be given all the chances to defend himself. Then we have rule number 20, which is provisions regarding officers lent to state governments. Where the services of a government servant are lent by one department to another department or to state government or an authority subordinate thereto or to local or other authority, the borrowing authority shall have the powers of appointing authority for the purpose of placing such government servant under suspension, and of disciplinary authority for the purpose of conducting a disciplinary proceeding against him, provided that borrowing authority shall forthwith inform the authority which lent the services of the government servant of the circumstances leading to the order of suspension of such government servant or the commencement of disciplinary proceeding as the case may be. So, if a government servant is on deputation to a state government office, then and he has been placed under any of the Rule 14 or Rule 16, any of the charges, then the disciplinary authority or the disciplinary action will be taken by the state government itself. But before taking any action or before finalization of the case, they have to inform the previous government, that is the central government, regarding all the information about the case. So, borrowing authority shall forthwith inform the authority which lent the services of the government servant about the circumstances leading to such order of suspension or such disciplinary proceeding. In the light of the findings in the disciplinary proceedings conducted against the government servant, if the borrowing authority is of the opinion that any of the minor penalties should be imposed, it may, after consultation with the lending authority, make such order on the case as it deems fit, provided that in the event of difference of opinion between the borrowing and the lending authority, the services of the government servant shall be replaced at the disposal of the lending authority. The opinion that any of the penalties under major penalties should be imposed on the government servant, it shall be replaced it shall replace his services at the disposal of the lending authority. So the in our case, the state government can impose only the minor penalties, and the major penalties can be imposed by the central government, that is the lending authority. So for all major penalties, the lending authority will pass the final order. So now we have come to rule number 21. Rule number 21 says provisions regarding officers borrowed from state government, etc. When an order of suspension is made or a disciplinary proceeding is conducted against a government servant whose services have been borrowed by one department from another, or from a state government or an authority subordinate thereto, or local or other authority, the authority lending his services shall forthwith be informed of the circumstances leading to the order of suspension of the government servant or of the commencement of disciplinary proceeding as the case may be. It is exactly the same as we have studied in the earlier case. The minor penalties can be given by the borrowing authority, and the final major penalties can be given by the lending authority, as here also. Let's directly go to our rule number 22. Rule number 22 is order against which no appeal lies. Notwithstanding anything contained in this part, no appeal shall lie against any order made by the president. So, if an order is made by the president, there will be no appeal. There cannot be any appeal against the order of the president. Any order of an interlocutory nature or of the nature of a step in aid of the final disposal of a disciplinary proceeding other than an order of suspension. Any order passed by an inquiry authority in the course of inquiry under Rule 14. So, appeal cannot lie against the order made by the president, and then any order of interlocutory nature or of the nature of step in aid of final disposal of disciplinary proceeding other than the order of suspension, and any other order passed by inquiring authority in the course of inquiry under Rule 14. Rule 23 is orders against which appeals lies. So appeal can be made against the order of suspension made or deemed to have been made under Rule 10. An order imposing any of the penalties specified in Rule number 11, whether made by disciplinary authority or the appellate or revising authority. Against all of them, appeal can be done. An order enhancing any penalty imposed under Rule 11. So, if an order of minor penalty is given to a government servant, he makes an appeal to the higher authority. The higher authority is still dissatisfied, and he enhances the minor penalty and gives a major penalty. So, against such cases also, a appeal can lie. Appellate authority. A government servant, including a person who has ceased to be in government service, may prefer an appeal against all or any of the orders specified in Rule 23 to the authority specified in this behalf, either in the schedule or by a general or special order of the president, or where no such authority is specified. So, who can be the appellate authority? For Group A, Group B, and Group C officers, the appellate authority can be the appointing authority, where the order appealed against is made by an authority subordinate to it, or to the president, where such order is made by any other authority, where such government servant is or was a member of central civil services, to the authority to which the authority making the order appealed against it is immediately subordinate. So highest level of appellate authority is president. Notwithstanding anything contained in Sub-Rule 1, an appeal against an order in a common proceeding held under Rule 18 shall lie to the authority to which the authority functioning as the disciplining authority for the purpose of that proceeding is immediately subordinate. So the appellate authority has to be superior to the disciplinary authority. It can be the immediate senior, provided that where such authority is subordinate to the president in respect of government servant for whom president is the appellate authority. Where the person who made the order appealed against becomes, by the virtue of subsequent appointment or otherwise, the appellate authority in such order, appeal against such order shall lie to the authority to which such person is immediately subordinate. Which means the same thing. So the most senior authority is the president. So Rule 25 is period of limitation of appeal. No appeal preferred under this part shall be entertained unless such appeal is preferred within a period of 45 days from the date on which the copy of the order appealed against is delivered to the appellant. So the appeal needs to be made within 45 days of receipt of the final order, provided that the appellate authority may entertain the appeal after the expiry of the said period if it is satisfied that appellant has sufficient cause for not preferring the appeal in time. So maximum time is 45 days. Rule number 27 is consideration of the appeal. In case of an appeal against an order of suspension, the appellate authority shall consider whether the light of provision of Rule 10 and having regard to the circumstances of the case, the order of suspension is justified or not, and confirm or revoke the order accordingly. In the case of appeal against an order imposing any of the penalties under Rule 11 or enhancing any penalty imposed under said rules, the appellate authority shall consider whether the procedure laid down in these rules have been complied with, and if not, whether such non-compliance has resulted in violation of any of the provisions of Constitution of India or in the failure of justice. Whether the penalty or the enhanced penalty imposed is adequate, inadequate, or severe, and passes orders confirming, enhancing, reducing, or setting aside the penalty, or remitting the case to the authority which imposed or enhanced the penalty, or to any other authority with such direction as it may deem fit in the circumstances of the case, provided that the commission shall be constituted in all the cases where such consultation is necessary. If such enhanced penalty which the appellate authority proposes to impose is one of the major penalties under Rule 14 and has not already been held in the case, the appellate authority shall, subject to the provisions of Rule 19, itself hold such inquiry or direct that such inquiry to be held in accordance with the provision of Rule 14 and thereafter on the occasion of the proceedings of such inquiry and make such order as deemed fit. If the enhanced penalty which the appellate authority proposes to impose the major penalties and an inquiry under Rule 14 has been held in the case, the appellate authority shall make such orders as may deem fit after the appellant has given a reasonable opportunity of making a representation against the proposed penalty. In order imposing an enhanced penalty shall be made in any other case unless the appellant has been given a reasonable opportunity, as far as may be in accordance with the provision of Rule 16, of making a representation against such enhanced penalty. In an appeal against any other order specified in Rule 23, the appellate authority shall consider all the circumstances of the case and make such orders as it may deem just and equitable. Rule number 28 is regarding implementation of order in appeal. The authority which made the order appealed against shall give effect to the orders passed by the appellate authority. Rule 29 is revision. Notwithstanding anything contained in these rules, the President or the Comptroller and Auditor General of India, in the case of a government servant serving in the Indian Audit and Accounts Department, or the member personnel, Postal Service Board, in the case of a government servant serving in Postal Service Board and Advisor, Department of Communication, in the case of government servant serving in or under the Telecommunications Board, or the head of the department directly under central government, in the case of a government servant serving in the department or office under control of such head of the department. The appellate authority, within 6 months of the date of the order proposed to be revised, or any other authority specified in this behalf by President by a general or special order, and within such time as prescribed in the general rules, may at any time, either on his own motion or otherwise, call for the records of any inquiry and revise any order made under this rule or under this rules repealed by Rule 34, from which an appeal is allowed, but from which no appeal has been preferred, or from which no appeal is allowed after consultation with the Commission, where such consultation is necessary, and may any other authority specified in this behalf by President, by general or special order, and may confirm, modify, or set aside the order. So revision is simply whenever. So revision is basically reopening of an old case and then the change in any order, altering the final order. That is, it may be either modification of the order, reducing the order, or enhancing the order, or keeping the order same, or it can also be the setting aside of the previous penalty imposed by the previous authority. So revision can be made by the appellate authority within 60 months of the date of proposed order. And Rule 30 is service of orders, notices, etc. Every order, notice, and other process made or issued under these rules shall be served in person on the government servant concerned or communicated to him by registered post. And then Rule 31 is power to relax time limit and to condone delay. Save as otherwise expressly provided in these rules, the authority competent under these rules to make any order may, for good and sufficient reason, or if sufficient cause is shown, extend the time specified in these rules for anything required to be done under these rules or condone any delay. So with this, we have completed our CCS CCA rules. Just by going through these slides, it will be easy enough for all of you to write the questions asked from CCS CCA. The most important topics under this CCS CCA rules is, one is rule number 10, which is suspension. Then rule number 11, under which the major and minor penalties are detailed. Then rule number 14 and rule number 15 is the procedure to impose the major and minor penalties. So question will mostly be asked either from rule number 10, rule number 11, or rule number 14, 15, 16. That's all. These are the important rules which will be enough for the exam. So with this, we complete our CCS CCA conduct rules. Thank you.